Hi, I'm Phillip Cha. I'm a mediator and founder of Cha Mediation Services. I specialize in mediating employment and business disputes. In this segment, I want to talk about what to do after receiving a mediator's proposal. When the parties in a mediation reach an impasse, one option is for the mediator to make what's known as a mediator's proposal. The way it works is that the mediator proposes a settlement to the parties at a number that the mediator picks. If both sides accept the proposal, then they can go ahead and prepare their settlement agreement. But if either side rejects the proposal, then there is no settlement, and usually the side that rejects the proposal won't know whether the other side accepted it or rejected it. But how did the parties get to the point of a mediator's proposal? There could be several reasons. Sometimes the parties just need more time to cool off and think about their options. Other times, one of the parties, usually the defendant in an employment dispute, needs more time to get additional settlement authority from a decision maker within the organization who wasn't available at the time of the mediation. Either way, once the proposal's made, each side needs to take similar steps before they can respond to it. First, each side, with the assistance of their counsel, should consider and evaluate any new information or arguments that came up for the first time at the mediation. New information, like a witness that comes out of the woodwork or a recent medical diagnosis, can have a big impact on the potential liability and damages in a case. If it does have an impact, then this information needs to be factored into whether to accept or reject the proposal. Next, the party should calculate and factor in the cost of rejecting the proposal and continuing with the litigation. This includes discovery costs, like depositions of witnesses that weren't completed prior to the mediation. It also includes trial prep costs, like expert witness fees, which can be substantial. In addition to the hard costs, the counsel should be advising their parties to also consider the intangible costs of litigation. This includes things like stress on an individual party, as well as lost business opportunities and loss of productivity for a company. In this sense, the mediator's proposal is the last chance saloon of litigation, and so the parties really need to understand that this could be their last opportunity to buy their piece before the stakes and the risks go up. Another thing to keep in mind is that most mediators' proposals come with a tight deadline, and that's designed to keep up the momentum of the settlement negotiations. But the parties shouldn't be afraid to ask for more time if there's a genuine need for it. Like most deadlines in litigation, a mediator's proposal deadline can also be extended. In fact, I see it as a good sign when one of the parties asks for an extension, because it tells me that they're seriously considering whether to accept it. Finally, if the mediator's proposal is rejected, the parties shouldn't lose all hope of reaching a settlement. A tenacious mediator will reach out to the parties and try to understand why the proposal was rejected. And if it turns out that the parties are still within striking distance of a settlement, then it's up to the mediator to continue to facilitate the negotiation in order to bridge the gap. Thank you for tuning in. If you like this video, please subscribe to my YouTube channel. You can also check out my website at www.chamediation.com. I'm also on social media. Links to my Facebook, Twitter, and LinkedIn accounts are in the description box below. And in the meantime, please stay tuned for more content. See you soon.